Yes, be ready. 5 seconds. Start. The Supreme Court has held that the limitation period prescribed under Section 468 of the Code of Criminal Procedure is not applicable for the filing of an application by an aggrieved woman under Section 12 of the Protection of Women from Domestic Violence Act 2005 Stop Stanza. The Supreme Court held as erroneous a judgment of the Madras High Court which held that the Section 12 application ought to have been filed within 1 year of the acts of alleged domestic violence stop. Section 12 of the Domestic Violence Act allows an aggrieved woman to file an application before the magistrate seeking various reliefs such as orders of protection or restraint or payment of compensation against acts of domestic violence committed by her husband-in-law's stop. Section 468 CRPC sets out the period of limitation for taking cognizance over offences stop. Depending on the sentence of the offence, various limitation periods are prescribed stop stanza. In this case, the Section 12 application was filed by the woman almost 10 years after she had left her matrimonial home stop. The High Court quashed the proceeding as time-barred as per Section 468 CRPC stop. The High Court said that as per Sections 28 and 32 of the Domestic Violence Act 2005 read with Rule 15 within bracket 6 of the Protection of Women from Domestic Violence Rules 2006 stop. The provisions of Criminal Procedure Code are applicable stop. Disapproving the High Court's approach, the Supreme Court held that a Section 12 application cannot be treated as an application in respect of an offence stop. The offence under the Domestic Violence Act arises only under Section 31 when there is a violation of an order passed under Section 12 stop. Filing of an application under Section 12 of the Act cannot be equated to lodging of a complaint or initiating of prosecution. The court observed stop stanza. The court added that the starting point for limitation for an offence committed under Domestic Violence Act would arise only after there is a breach of an order passed under Section 12 of the Act stop. There would never be a starting point for limitation from the date of application under Section 12 of the Protection of Women from Domestic Violence Act 2005. The bench comprising Justices U. Lalit and P.S. Narasimha stated stop stanza. The appellant had contended that the offence under Section 31 of the Act will be said to have been committed only after the breach of an order passed under Section 12 of the Act, and there is no limitation under the Code or under the provisions of the Act stop stanza for filing of an application as such stop. The respondent, on the other hand, contended that the starting point for reckoning the period of limitation ought to be from the date of application and as such stop. The High Court was justified in observing that the action was barred by time stop. To address these rival contentions, the bench referred to the provision of the Act and observed thus stop. The provisions of the Act contemplate filing of an application under Section 12 to initiate the proceedings before the concerned magistrate after hearing both sides and after taking into account the material on record stop. The magistrate may pass an appropriate order under Section 12 of the Act stop. It is only the breach of such order which constitutes an offence, as is clear from Section 31 of the Act stop. Thus, if there be any offence committed in terms of the provisions of the Act, the limitation prescribed under Section 468 of the Code will apply from the date of commission of such offence. Stop. By the time an application is preferred under Section 12 of the Act, there is no offence committed in terms of the provisions of the Act, and as such there would never be a starting point for limitation from the date of application under Section 12 of the Act. Stop. Such a starting point for limitation would arise only and only after there is a breach of an order passed under Section 12 of the Act. Stop stanza. The court observed that the High Court wrongly equated filing of an application under Section 12 of the Act to lodging of a complaint or limitation of prosecution. Stop. While allowing the appeal, the bench observed. Stop. It is thus clear that the High Court wrongly equated filing of an application under Section 12 of the Act to lodging of a complaint or initiating of prosecution. Stop. In our considered view, the High Court was in error in observing that the application under Section 12 of the Act ought to have been filed within a period of 1 year of the alleged acts of domestic violence. Stop. The respondent also contended that in A. Prasad versus Rupal Jindal, it was held that if a magistrate takes cognizance of an offence, issues process without there being any allegation against the accused or any material implicating the accused or in contravention of provisions of Section 200. Stop stanza.